What's up? What's up? What's up, y'all? Happy Friday. Welcome to the chat, everyone. How you guys doing? I haven't been live in a whole week, y'all. I know. Y'all, like I've been trying to keep y'all updated on my community tab. It was my kid's birthday trip. So we treated them to a vacation for their birthday instead of having a birthday party. Then when I got home, y'all, I was tired. I was exhausted. I had to listen to my body and I had to just chill out. So there was no way I was going to be able to go live. And plus, I was still gearing up for this live that I'm doing today. So I was trying to get all the information together, trying to keep my head over water. So I neglected y'all, but it was for a good reason, y'all. I'm so sorry. Late, but charge it to my head and not to my heart, okay, y'all? So again, hello, welcome to everyone in the chat. Like I said, let me go ahead and do roll call. Hey, Ty, I was in the bushes listening to your live, but I was getting ready for mine, so I couldn't really chat. Hey, AK, hey, Meezy, hey, India, hey, Cece, Miss Brader's Life, Chrissy, thank you so much. Yes, I'm so happy that I'm here to talk to y'all today and get y'all up to date with this crazy trial. Hey, Cool Jazz. So, if you guys cannot tell by the title, we are going to be talking about the trial that has shook the nation. And when I say nation, I mean everybody, because although us people of color was kind of shocked, baby, let me tell y'all, I have been in the bushes. I have been in the trenches. Okay? And when I say they, and when I mean they, I mean the white tea people, they was going at it, baby. I didn't know if it was safe. I ain't never been in that type of environment. I was kind of scared for my life. I said, these mother effers are some thugs. They are down and dirty on a whole different level, okay? They don't play about theirs. Let me just put it like that. So, baby, they was down and dirty. They was down and dirty in the Wisconsin make believe lawyer land. I mean, baby, I was scared for my life. I can't say it enough. They was really tripping over there. Okay. So, if you guys did not know, I am here to give you guys all the information, wrap all the information up in a bow and serve it to you guys. If I can get some bows in the chat, please, before we get started. If y'all did not know, that is my official emoji, because what I do is I get down in the trenches, like I just said, Miss Berta's Life. Yes, in the trenches for y'all to wrap everything up and deliver it to y'all in present style with a bow on top, okay? Now, I'm not in no way trying to sway your opinions, make you act off impulse, or poor judgment off of the information that I'm presenting to you. Everything is alleged, and these are just my takeaways from the information that was presented publicly. This one was a public trial, so this ain't even all things was alleged. This was what they did in court, baby. Period, point blank. This is a little too crazy for me. So, thank you guys for dropping the bows in the chat. So, like I said, this was a crazy trial, and the trial was over 18-year-old Cal Rittenhouse, y'all. Now, y'all may not know who he is. The Shade Room may have told y'all some crazy stuff. Y'all may be known for that little picture that's on the screen right now of the cry face. And y'all still like, who is this man? Who is this man? Because he's always on the Shade Room too. Well, Cal Rittenhouse was at the time a 17-year-old Wisconsin native who was at a Black Lives Matter protest and shot two people and injured another. So 3 people were shot in his actions. Now, why was he there? Let's start with the first crucial part, and that I feel like a lot of people need to know, and this is a reason why a lot of people was tuned into this. Now, the protest that was taking place on August 25th was because on August 23rd, Jacob Blake was a Black man that was shot in the back 4 times by a white officer while he was trying to get inside of his car. Jacob Blake is still alive today, but he is partially paralyzed because of the actions of the police officer. And Jacob Blake is actually on the screen right now. You guys have probably seen those pictures, but kind of probably forgot about this. This was a very big part of what went down in Kenosha, Wisconsin, because when I say, baby, they went hammer bammer crazy off of Jacob Blake, baby, they went hammer bammer crazy, baby. So how does Cal, a 17-year-old man or boy, shall I say, get involved and rack up 5 charges? Let me tell you. Cal was a part of a vigilante group. Yes, you guys heard it right. A vigilante group that was basically set up to protect the land of Wisconsin, Kenosha. Now, I know y'all probably wondering, like, okay, but don't they have police officers? Yes. And that's why we're kind of confused. But nonetheless, Cal being 17 years old, actually, and because of the graphics, I cannot post it. But he geared up that night to be a part of the vigilante group to stop the rioters from destroying property, breaking into businesses, setting fires, looting, all that jazz. He was there. He was Superman, baby, 17-year-old Superman. And in his efforts to stop all of this, he was strapped with an AR-style semi-auto rifle, you guys. That is also known as those jazzy words. Just take from it a military sized weapon, you guys. I'm gonna say it one more time. He had an AR style semi-automatic rifle, baby. The big ones. Yes, he did. And in the driving by his mama, that is driven by his mama, he absolutely was, because he was 17 years old. He was a part of this vigilante group. Now, in this vigilante, if you guys forgot the news, it was a lot going on that night. I will be honest. They was setting fires, they was breaking into cars, they was going hammer bammer crazy, like I said. And he actually shot 2 people, one by the name of Joseph Rosenbaum and another by Anthony Huber. Now, Anthony Huber was a protester. Joseph Rosenbaum was someone that had just got discharged from a psych facility for trying to unalive himself, and he just happened to be there. And then finally, he did shoot and injure a 27-year-old man by the name of Gage Grossenkratz. I'm not really sure how to pronounce his name, but that's close enough. So what happened after he shot these 3 people? He went home, you guys. Now, I'm giving you guys the short story because the meat and potatoes is the trial. So in the short, he shot and killed Joseph and Anthony. Joseph was someone that was allegedly screaming, shoot me, shoot me. Like, he just happened to be in the wrong place at the wrong time, but he was very, very hyped up. And they said that he was basically, like real aggressive. Now, on the stand, there was another witness that said, although he was aggressive, he was not a threat. And in self-defense is what Cal is stating. So he basically said that he had to shoot Joseph because Joseph was charging at him with a mob of people. The same for Anthony Huber. Huber allegedly took a skateboard to him and was going to throw it at him. So that caused him to shoot him 2 times as well. So he shot Joseph 4 times and shot Anthony 2 times, killing them both and leaving them 4 dead, you guys. Yes, and I have to put it frank. Now, the last person he did shoot was Gage. Gage was trying to unarm this 17-year-old thug by the name of Cal. Now, this thug had a military-style weapon, and he had already shot 2 people. The crowd basically said that it was so much going on, they heard multiple gunshots. They didn't know where it was coming from, but Gage allegedly saw the 17-year-old thug Cal, and he thought in his best interest he was going to charge at him and disarm him. Now, Gage did have a weapon as well, and so the defense was saying that basically Cal was scared for his life because Gage had a gun, even though he had a bigger gun, and he shot him. Now, he only shot and injured him, so he was able to take the stand. Now, I know y'all probably like, this don't even make sense, baby. What are you talking about? A 17-year-old thug is out in the streets and he has killed 2 people and injured 1, and he was able to go home? Yes. The 17-year-old thug, Cal, actually went home that night. Now, what happened next was the officers of Kenosha basically issued a warrant and went live the next day to say that they were looking for Cal. Cal did turn himself in and he was released on bond a few hours later. Now, when he was released on bond, the 17-year-old thug was happy about it. He was seen wearing a free as fuck shirt. He was in a bar. He was having a good time. This 17-year-old thug had he did not feel bad for his actions. He had no sleepless nights. He was free as fuck, you guys. So let me just recap, you guys. This was something that happened in the efforts of Jacob Blake, who was shot by a police officer and partially paralyzed. So the rioters or the protesters were protesting for Black Lives Matter and for police reform. Now, the vigilantes was, of course, in efforts of the police. So this right there was already a very high profile case. A lot of people was tuning in to see what happened with the 17-year-old thug and how his life was going to be playing out on trial. Now, Cal was facing life in prison if he was going to be convicted of all 5 charges. Okay, he was facing life in prison. Now, this became a quickly escalated case because early on, the judge name is Judge Bruce Schroeder. He is flashing on my screen as well. Okay, impasse, we will get to you next, baby. I got it all covered and wrapping it up for a bow. Go ahead and subscribe to me. Thank you for commenting down in the chat. I appreciate you, baby. Now, anyway, Judge Bruce Schroeder is a 75-year-old judge. He is the longest serving circuit judge of Kenosha. So he is a real deal judge. His name rings bells in the streets, and he allowed for this case to be on television and played out live. Now, before that happened, there was a lot of rules that he set in place. He set these rules in place early on. And just know, if you guys watch this trial, he was so particular about the rules. Some of the things that happened was a huge contradiction because the way they say he's so about rules, we'll get to how I can't understand what rules he's so serious about, but so lenient on others. Now, jumping right into it, I did go ahead and I'm going to break this down into 5 facts. Since I already laid the ground foundation, we know that he shot 2 people, killed them, and injured 1. We already know that the 17-year-old thug, Cal, has been found not guilty, so he is free, even though he was facing life in prison if he was convicted. Now, the 5 parts I'm going to go over is the trial, because a lot of people had questions about the judge being known for saying that that the prosecutors cannot call the victims victims. We're going to go over the gun charge that was dropped off of the 17-year-old thug, Cal Rittenhouse. We're going to go over the judge's behavior, as well as his cell phone ringing, his improper use of reading magazines while the trial was going on. We're going to go over the prosecution and how this really split a town in half, and how the 17-year-old thug took stand, which is really, really uncommon when you're on a high profile case like this, and then also landing him able to pull the names of his jurors that was going to determine his fate. I got all the information for you guys, so jumping right into it. First things first, a lot of people knew the headlines of the judge not allowing the victims to be called victims. I have the video here of the judge explaining why he is not going to allow the victims to be called victims. Okay, so let me go ahead and get that for you guys, because although this is a real deal case, I want to bring up his words and not anything that could be misconstrued. I don't want the judge coming from me.
The word victim is a loaded word. And I think alleged victim is a cousin to it. Let the evidence show what the evidence shows, and if the evidence shows that any or more than one of these people were engaging in arson, rioting, or looting, then I'm not going to tell the defense they can't call them that.
Okay, so if you guys did not hear that, basically the judge was saying that the word victim is a loaded word, and that basically he does not think it's fair to be called a victim when the defense is trying to present their side as well. So to be fair, they will not be called victims. But he said it was fair to call the non-victims, but we're going to call them victims over here. They could call them rioters, loiterers, and people who enticed violence, even though they're not here to defend themselves, right? So a lot of people had a lot of issues with that. Like, Judge, how can you say that we can rationally call the victims rioters, loiterers, because we saw that, but we can't call them victims, even though we saw the 17-year-old thug Cal kill these people with a military style weapon. So a lot of people had issues with that, and that was the strike number one. This was pre-trial. So once a lot of people got wind of this, they tuned in, baby. They tuned in. They were like, you gotta be kidding me. We gotta see what's going on in Kenosha, because we already know Jacob Blake is over here partially paralyzed, and they were fighting for his rights and justice for him. And in that moment, two other people was killed by a 17-year-old thug in broad daylight. I mean, it was nighttime, but we're gonna say broad daylight for dramatic purposes. And then we have this judge who seems to be straight out the gate impartial. He is straight up saying that we cannot call these people victims, but we can't call them what they did. But we cannot call the 17-year-old thug a murderer. So that is what people heard. And baby, I heard it too. I am not a lawyer. I did study political science, but baby, I'm a little rusty. So I'm just giving you guys the raw clips, and you guys can take away from it what you want. Now, like I said, 17-year-old thug Cal Rittenhouse was facing life in prison if he was convicted of the 5 charges. Now, one of his charges that he was charged with was, let me get my notes, he was being charged with carrying a firearm, you guys. Now, the firearm charge was dropped. He was being charged with illegally possessing a firearm underage. Now, his defense team, and this is the thing about court, you got to have a good defense team. And I will give it to the 17-year-old thug. His defense team went through every section of the law, and they was able to find a loophole. The loophole was that there was an exception to the law that minors are able to possess shotguns and rifles as long as they are not short barreled. So they cannot be shorter than 16 inches. This was what they petitioned to the judge, and the judge did grant it, and he got his charge dropped for the firearm. That ticked a lot of people off, because they're like, look, at the end of the day, this was a 17-year-old thug out in the streets where he did not belong. He is underage, number one. He had a very serious firearm that had 2 rounds. I forgot to mention, he had 2 rounds on that AR. Like, he was out for blood. And again, we have to keep highlighting his age, because it makes a big deal as to what went on in his mind frame. We cannot hold him to the standard of an adult, because his mind was so immature. And that's why he was literally had no business being there or being a vigilante. Now, when I was looking up the shotgun charges and everything that was taking place, you guys, I'm not gonna lie, I was looking up everything, because I was kind of confused as to what this really meant, how this was. So I happened to be scrolling on TikTok, and I actually found a video where someone broke it down. Now, this is someone that supports Cal Rittenhouse, but he actually was able to bring up the sections and explain the charge in detail. So we are going to go ahead and watch that, just so you guys can fully understand what went on in this with this charge. Bear with me while I get it. Sorry, y'all. I had to find it. I was like, what in the hell? So just allow me one moment to go ahead and share my screen to pull it up for you guys. I could not find it. TikTok be doing something weird. I didn't want to like his. I didn't want to like his video because I don't like him, but I'm gonna go ahead and play it. One moment.
Prove, etc. Then number one, the defendant was under 18. Number two, and that the dangerous weapon was either a rifle, etc. So he's going to instruct the jury that either they need to prove Kyle was under 16, which obviously he was 17, or they have to prove he had a short barrel rifle, which he didn't. So it's basically tossed because they can't prove that. So for all the people that were saying I couldn't know this because I'm not a lawyer, I'm sure you'll apologize and admit that I'm right. And also, if I was right, then does that make me a lawyer? Walmart law for the win again. The crazy thing is the defense, the prosecution, and the judge still don't understand the statute, though.
I concede he's in violation of 29593.
Why would you concede that? If you're not trying to obtain hunting approval, not having a certificate is irrelevant. It'd be like saying you're violating driver's license laws by not having a driver's license, even though you're not driving.
This statute doesn't apply to 16 and 17-year-olds, period.
That's wrong. It only doesn't apply to 16 and 17-year-olds that have a long rifle or long shotgun. It still applies to them if they have any other dangerous weapon. And the prosecution is making this same mistake.
That simply being 17, he is in compliance with that. It swallows the whole statute, and the statute makes no sense.
Which again is wrong, because any 17-year-old carrying a dangerous weapon defined under this statute, as long as it's not a long rifle or long shotgun, they violate that law. Why the hell do I have to explain it to these guys? Somebody send these guys my video. Though the judge had a fun response to the prosecution saying the law doesn't make any sense.
The statute makes no sense. You're out of luck.
Then the judge made a point that I've made before too.
The penal laws are construed strictly, but the basic rule is that the ordinary people should be able to understand what their laws are, so they know what conduct is allowed and what isn't. And I've been wrestling with this. Now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for, I'd hate to count the hours that I've put into it.
So there you have it. I can't wait for all the apologies. Walmart lawyer off. Well, good news that Kyle's possession charge was basically tossed.
So it'll be exception.
Okay, so there you guys have it. That is basically the breakdown of what exactly the charge was and why it was thrown out. Basically, there are statutes, sections that basically break down what the law entails and why he wasn't in violation of the charge. Now, I'm going to be completely honest with you guys. The prosecution did a poor job, as you guys did hear him say, like the law doesn't make any sense. Well, you prosecutors should have did your due diligence to make sure that the sections that you were charging him with, which the section that he charged him with, there was a loophole. You had to be under the age of 16. He was 17, and the barrel had to be, it couldn't be shorter than 16 inches, which is known as a short barreled rifle or shotgun. So because it was longer than 16 inches and because he was over 17 years old, they had to eat that charge. They had to get rid of it altogether. And that was a big blow to the prosecution because that was the whole issue. He was in the streets of Wisconsin with a military style firearm. And not only did he carry that, and he had it strapped on him. I wish I could show you guys, but I know how YouTube is. He had it strapped on him. He was ready. He also killed and hurt 3 people, or 2 people. He killed 2 people and hurt 1 person. So the prosecution did a horrible job. Now, there was one more piece of evidence that was throughout that the prosecution was trying to make a part of the case. The biggest thing was, again, we know how bizarre it is for a 17-year-old child to be in this type of environment. And the prosecution wanted to present that basically this is something that this thug liked to do. There was a key part of evidence where Cal, the thug, was on video recording someone breaking into a store, and he said, "I wish I had my gun so I could pow them." And the prosecution wanted to present that, but the judge tossed it out and basically said that that does not prove intent or that he went to the protest as a vigilante with the thought process of hurting someone to defend property. The whole narrative is that he went there with this machine or this military style gun to defend property, but the judge would not allow this piece of evidence to be presented in the courts. I actually have the video, so I am going to play it for you guys right now, just so you guys can see how big of a deal it would have been if it would have been played, because I have another key part that played out in the trial that this relates to and why the prosecution and the judge was arguing so much during this trial. Let me get that for you guys. Sorry, that's the wrong one. All of my tabs are titled the same, so bear with me, y'all. I'm sorry. Okay.
Show his state of mind. Rittenhouse is not seen in this video, but prosecutors say he is heard. He's heard wishing he could shoot at people he believed were shoplifting. Here is that video in its entirety.
It looks like one of them has a weapon. She hung up. Bro, I wish I had my AR. I'd start shooting rounds at them.
2 people died when Rittenhouse opened fire on protesters in Kenosha last.
So as you guys heard, he basically said that he wished he had his firearm so he would be able to protect the property that he was seeing those people break into. And it's really bizarre because this is someone that's a 17-year-old child. Like, why do you have such a passion for, well, there's no problem with having a passion for standing up for things. Go enlist and to be in the military or be in the police. But why would you say, I wish I had my gun so I can shoot them? Like, that is the train of thought that the prosecution was trying to display within this trial of, this is not something that was just, he was scared for his life, because that's what he was trying to say. That's what the 17-year-old thug was trying to say. He was scared for his life. He really had no choice but to use this gun. Meanwhile, the prosecution, even though they did a horrible job, they were basically trying to say, no, you went there to protect property, and in your mind, your 17-year-old thug life mind, you think in order to protect property means to shoot people. That's the only reason why you came to a riot or a protest with a military style gun. Like, it does not make any sense. Now, a lot of people, like I just said, thought that the prosecution did a horrible job at fighting for this case and getting the win. Now, when I said that I was in the bushes and I was in the trenches and I watched a lot of YT people fight, baby, let me tell you, they dug in the prosecution's ass. If you guys are familiar with Game of Thrones, it's one of my favorite shows. I love that show. I think I'm going to binge watch it again. They went after the prosecutor and called him Littlefinger. If you guys know anything about Game of Thrones, Littlefinger and him actually look alike. The prosecutor look alike. So every time he would flop on stand or every time he would do something and get yelled at, I mean, the commentators was like, Littlefinger is at it again, flopping. They could not stand the prosecution and they went into his ass. But on top of it, they felt validated in ripping into his ass because they saw that the judge also ripped into his ass. Now, like I said, the judge is a 75-year-old man. He is one of the longest standing circuit judge there is in Wisconsin. So he allegedly was no nonsense. Even though he was seen on stand reading magazines, his phone went off with the Trump campaign ringtone. He would not let Littlefinger have a word in edgewise. He could not stand it. And there was two memorable moments in this trial that really, look at him on the screen. That was him reading a magazine. Oh, and he also was very, 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 very vocal about lunch. He loved lunchtime. I mean, baby, he couldn't wait for lunch. If he wasn't on his cell phone doing this, and if he wasn't reading a magazine, doing this, baby, he was looking at the clock because he wanted lunch. So a lot of people was also digging into the judge's ass as well, because a lot of people just could not believe that he knew he was on TV and he was acting this way. Like, people was calling him out. But back to what I was saying, there was two instances that stood out during this 13-day trial. And the two instances took place when Cal was actually on the stand. Now, when the thug was on the stand and he was being cross-examined by Littlefinger, that's what I'm going to call him, Littlefinger basically asked him why he refused to speak until he had a lawyer. And the judge was pissed off. He basically was like, I knew from the moment you opened your mouth that you had no business. Like, how dare you? That is the first law. It's been around 40 plus years. How dare you ask him about why he did not want to speak without counsel being present? So basically, the judge, a lot of people felt like the judge was coddling the thug. Like, they felt like the judge was partial. Like, as you guys see on the screen, the thug is sitting right next to the judge and his counsel, and they are looking on the screen while they're presenting evidence. Most of the time, the judge is never to be approached with the prosecutor or the thugs on stand. Like, those things are never supposed to come in contact. But Cal was so close to this judge, and the judge came off as very impartial, and that he could care less about anything that the prosecution had to say. He read magazines, but when it was time for the defense, he kind of came off as if he was rallying around the defense, and that he, was rooting for them. So when Cal took the stand, this was something that was a very, very vital part of this trial, because, as you guys know, a lot of defense people do not, a lot of defense lawyers do not have their clients go to stand, because it can go the wrong way. So they took a gamble by putting Cal on the stand. And what took place when he went on stand with Littlefinger, baby? So I have the clip for you guys. It's about a 10-minute clip, but it is crucial regarding the last clip that I showed you guys, in regards to him saying that he wished he had his gun to shoot the people that was on breaking into the store. Now, I'm going to go ahead and play this clip for you guys, just so you can see the relationship between the judge and the prosecution. Like, this was a very thick, tense type of relationship. And a lot of people was like, whoa, like, the judge was no nonsense, but he let a lot of shit slide on the defense side that he would not let slide on the prosecution. So again, a lot of people just could not deal with the judge because he came off as very biased.
Years old. That was a lie too, right?
No, I didn't tell anybody my age that night. I have one in my closet.
And maybe I didn't express myself clearly. You were not a member of the Antioch Fire Department, correct?
I was a member of the cadet program, which was through the fire department.
So you'd go out and fight fires.
We can go on ride-alongs, but we can't go into burning buildings for liability reasons.
You'd go out there and you'd save people from burning buildings?
Not me personally.
Because as a cadet, they would never let you anywhere near that, right?
They wouldn't let any of the cadets go into an actual live fire.
At the end of whatever this program is, you weren't actually going to be an official firefighter, were you?
No, it's to help prepare you for the firefighter academy, firefighter EMT academy.
And you weren't going to be an EMT at the end of this program either, were you?
No.
You know that to be an EMT, you have to be 18 and a high school graduate, correct?
Depending on the state, in Illinois, you can take a class at the college at 16 and you can have your EMT license by the age of 17. I wasn't in that class, but in Illinois, you can.
You never did any of that.
No, I was online school.
The night of August 25th, you're here in Kenosha, Wisconsin, saying you're an EMT, correct?
Yes.
That was a lie.
Yes.
You were also telling people you were 18 or 19 years old. That was a lie too, right?
No, I didn't tell anybody my age that night.
You never volunteered it at all, did you?
I didn't.
Because you knew as a 17-year-old you shouldn't have been there, right?
No, I just didn't find it relevant to give my name. Well, I gave my name, but my age to anybody. It wasn't something that came up in conversation.
It's because you felt if people found out how old you were, they'd realize you shouldn't have been there, right?
No, it just because it didn't come up in conversation. If somebody would have asked, I would have been like, yeah, I'm 17.
So you felt that as a 17-year-old, it was appropriate for you to be out on the streets of Kenosha with an AR-15 that night. Fair?
I believe I had any other right to be there as anybody else,
As any other adult.
as anybody.
But you weren't an adult.
Now, as you guys see, and sorry, I have to take a pause because, fair use. But as you guys see, the prosecution is basically trying to figure out Cal's intent for even being there, knowing that everyone around him had no earthly idea that this boy was underage and that this thug was out there without reason. Like, he had no reason. He claims that he was there to be a part of this vigilante, but he was actually on record lying. He told people while he was there that he was EMT. He is not EMT. So the whole time this thug is actually acting as if he is some savior, and he is out here as an EMT carrying a military style weapon, and the whole time he's lying. He did not tell anyone his real age, because if he did, they wouldn't have had him out there. They would not have had him out there. And on top of it, to make things worse, this 17-year-old thug, because that clip already played and I'm not going to rewind it, but this 17-year-old thug is currently in college to be a nurse. So this 17-year-old thug had no regard for the lives that he took. Even though he felt like his life was in danger, he left them for dead. But he is trying to go to college and sign an oath to protect and provide care for any and everyone. Baby, I am scared. Baby, I am afraid. Don't let me get sick in Wisconsin and get him as a nurse, because that oath, after he's already been on record lying. So I'm going to go ahead and continue to play the clip, because this is a very important clip. And the prosecution, in my opinion, did a great job. But because this judge already laid out the law with the prosecution, none of it was able to stick. But we needed to know this information to be able to understand what the hell this 17-year-old thug was thinking. So the prosecution was basically diving down, and they started with this whole, you told them that you was EMT, but how old do you really have to be an EMT? You didn't offer your age. You lied. He had to admit, yes, he did lie. So it's showing a pattern for this type of person that this thug is. So I'll go ahead and let it finish.
No.
You indicated that you were working at the Recplex and had been working at the Y before that. Is that right?
Yes.
That was a YMCA down in Illinois, correct?
Correct.
And you had gotten furloughed there when COVID hit in March?
Yes.
And you had only started working at the Recplex on August 14th, correct?
I believe I got hired before that, but I was on vacation on August 14th, so I was on vacation, so I couldn't start until August 14th.
Your first time working at the Recplex was on August 14th, correct?
I believe that was my first day.
And then you worked the week after that from August 17th to August 23rd, correct?
I believe so, till August 24th I worked.
And then your final shift was on August 24th, correct?
Yes.
You worked a total of 41.5 5.5 hours at the Recplex, correct?
That's the number you got?
And you were a lifeguard.
Yes.
You were walking around their swim area with one of those red, long, life-saving things, monitoring the pool. Correct?
Rescue tube, yes.
So, but that was at the indoor pool at the Recplex?
It was at the indoor. It was at the. I don't know if you're familiar with the Recplex.
I am.
I guarded the water park area and the competition pool.
So they've got a water park area with a slide and a zero entry pool. Is that right?
Yes.
And then next to that, they've got a larger, almost Olympic-sized pool where swim meets happen.
50-meter competition pool divided in half to make it a 25.
Okay, and you were lifeguarding at both of those.
I would rotate. We had rotations, and me and other guards, we would do three. We had 3-person shifts. We would rotate out watching the different areas of our zones.
You indicated that at no time did this gun, this AR-15, ever leave the state of Wisconsin. Is that right?
Other than the night after, other than that.
Before the shootings.
Correct.
There was a time, though, where you wanted to have it with you down in Illinois, isn't it? It wasn't there?
I believe there was a time when me and Dominic were mad at each other. Yeah.
You were mad at Dominic?
Me and Dominic were mad over something.
And you wanted to have the gun with you down there?
I think I said something along those lines.
Now, if you guys noticed, this to me was a jaw dropper because the prosecution was not talking about him and Dominic. Dominic was another person that was at the protest that was there. That is his friend. So when the prosecution was asking, he was referring to the video that I previously showed you guys. But as you guys see, this thug said there was another time that he wished he had his gun, and it was when him and his best friend was arguing. The prosecution was like, because that's not where he was going. That's not where he was going. That's not even what he was talking about. But you just literally said on stand that, yeah, you did want your gun another time. And it was when you and your best friend was arguing. Your thought process is jaded. If you think that you need to have a gun at any time of an altercation, especially with your best friend at 17 years old, and the type of gun that you have is a military style gun, like, I can't repeat it enough. It's a huge gun. So that part was always funny to me because the face, like, and when the prosecution kept going, you can tell Cal was like, oh shoot, I shouldn't have said that. But there was no taking it back. So I felt like this was something that was completely brushed over, but baby boy is going to be a problem. This thug is going to be a problem.
You'd agree with me that let me back up for a second here. You have testified to this jury that you used deadly force against Joseph Rosenbaum, Anthony Huber, the man who attempted to kick you in the face, and Gage Grosskreutz on the night of August 25th, correct?
Yes.
And you did that because you felt that your life was in danger from those 4 people, correct?
Yes.
And you are telling this jury that it was, in your mind, justified to use deadly force to protect your own life, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself, so.
Please listen to my question and answer my question if you can. You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from tipping over a porta potty, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone from lighting some traffic cones in the middle of the street on fire, correct?
Correct.
So you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
So this is the judge basically dismissing the jury so he can get in the prosecution's ass. During this time, there's no words, there's no movement that's supposed to be done. So as you see, the video mutes, everyone stands up while the jury does exit. It is just the witnesses or the people that was viewing the court in the courtroom. It was just the lawyers, as well as it was the 17-year-old thug Cal that was on stand at this time. So once the video audio starts back again, you guys will hear the exchange of just how much the judge coddles, but he can't remember everything that goes on with this because his ass been on his phone and reading the magazine.
Mr. Richards?
Your Honor, Mr. Binger is either forgetting the court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
Mr. Binger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not a motion.
Excuse me. I did. I granted.
We did not move
That
to
was
reconsider.
their motion.
We have not filed
forgive
any
me.
motions to reconsider in this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you without any advance notice to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed another acts motion on this exact issue because in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record. And
this judge was like, don't talk to my baby that way. That is not what happened. That's not why he had the gun. That's not. Like, that's literally all that I could see. He was ticked the fuck off. That Littlefinger, his real name is Finger. But anyway, Littlefinger, how dare he treat his non-client that way? Like, this judge showed his ass. This judge was pissed.
why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this.
Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes.
He had the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. I want.
May I respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So to your point, Your Honor, you're arguing that this August 10th incident, one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats, that means the defendant has to defend himself. So with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting with the defendant to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling because I thought your ruling was if the evidence in this case made that more relevant, you would admit it or at least consider it an admittance. I believe, based on the evidence that we've heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements to, Your Honor, because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, what's the court?
So, like I said, this clip right here, this is when I personally knew the case was over, because the thug had already been on stand. He had already did his fake crying. The judge had already, mind you, most of the time when someone's on stand and they get emotional, most of the time the lawyers are the ones that be like, can we have a recess? The judge was like, okay, we got to take care of our little son, so we have to get him off the stand. Like, we're going to have a recess real quick. We're going to take a break. Even though we know that Cal, the thug, could care less what he did, because at the end of the day, even if his life was in danger and even if he was self-defense, He let those 2 people die in the streets, and he went home knowing that he should have called the police, knowing that the ambulance should have came and tended to them. Like, if you really cared that much, you would have got that taken care of. That boy went to sleep like a newborn baby. And the judge, as you guys heard, he would not allow the prosecution to even make the defense, even though the defendant and the lawyers already had basically showed a pattern of this man and his fetish for his gun. Like, they have already shown it. But when Finger went to try to basically prove his point, the judge was not having it. Hence, why the juries was not in there. So all of this was admissible. Like, this was not even in the docket. None of it. And this is what really was the turning point for this trial, because it was like, for goodness fucking sakes, if we can all see it, we can all come to the same conclusion. How is the judge going to say, now you're talking about his beliefs? No, he just said it out of his own mouth. And his beliefs is a big deal in this case, because we are talking about stand your ground. And a lot of people don't understand that stand your ground, there's a lot that entails about that law. And standing your ground does not mean to kill. To stand your ground, you cannot provoke violence, as he did. He was out there provoking things. He was out there with the mindset of protecting property and using deadly force. He was out there underage with an underdeveloped brain, smoking. He was there was another witness that was on stand a few days earlier in the trial that said that Cal's thug ass was chain smoking that whole night. It was like, dude, you're not even old enough to smoke, number one. And why are you chain smoking? So his mental was already wrong. He had no business being there. And the intent shows, because he had a gun. You want to protect property because that's what he allegedly was there for. Why did you bring an AR? But you knew that you cannot protect property with deadly force. But you still came on this protest with a weapon that does not politely get rid of force. Like, it's deadly, point blank, period. So I just was baffled at the judge and the way that he was really treating the prosecution. Even though the prosecution did do a lot of things that was like, dude, you fumbled. But this part I felt like was the money making and the change point that really could have got the jurors to understand where the thug's mind frame was. And because the judge was so up in the ass about it, it was thrown out. It was thrown out. Now, to further go into detail about the judge and why a lot of people felt like he had some very faulty practices, this judge made it known that he was watching the media. He made it known that he was aware of what media was saying about him and the trial. He talked about it every day. And a lot of people know that the jurors cannot watch media. They cannot watch anything regarding the case to sway their opinions. But it's crazy that you have a judge on the stand that is so in the know about what media is saying, but you're not biased. I feel like that was a contradiction to me. I'm not sure if the judge is able to watch the media and watch interviews that go on about the trial, but he was vocal about what he's seen. And I'm going to play a clip a little bit later where he basically was trying to explain some of his stuff because he saw the media talking about it. Now, the judge, like I said, he was called out for a lot of things, but the last final piece, after the prosecution and the defendants did their closing arguments, when it was time for the jury to deliberate, the judge allowed for the thug, Cal Rittenhouse, to actually select his jurors. And a lot of people were shocked. So basically, what happened was the defendants wrote each juror's number on a piece of paper, folded it up, and they put it in the barrel for the thug to draw the jurors that was going to decide his fate. Now, this is not an uncommon practice. I actually had to phone a friend, and they did let me know that this is not an uncommon practice as far as drawing the numbers of the juror. Usually, typically, the person that draws the numbers after they randomly select it or after they write it down is the clerk. So the lady that told Finger to slow down, she would be the one that would actually draw the names. But the thug was able to do it. And a lot of people not knowing that this thing was a thing, was like, what the fuck? We're treating this like this is the lottery. We're treating this like this is some Monopoly game show. I even said it. I was like, I cannot believe this. I cannot believe my eyes. Like, this trial, this 13 days of trial was like, what the hell? I've never seen anything like this. And it really, really like quenched my thirst to really get back into poli science and learn about courts and learn about our laws, because I feel as a person of color and as a woman, I need to know the shit that's going down, because baby, you don't know unless you know. And the best way to hide information is to put it in a book. So I was like, I have to get my hands on some knowledge about courts and about trials and how things go. So I'm going to go ahead and play the clip where the judge is basically letting it be known, hey, I seen what y'all been saying in the media, and I'm going to go ahead and clear up some things. So in this clip, he does clear up why he had him pull some names, and he does clear up the fact again of why he doesn't allow the word victims to be used. So I'm going to go ahead and play that for you guys, just so you guys can hear exactly what the judge said and why he does what he does.
As long as I'm talking about it, I guess I'm going to talk about that too. The business about people not being identified as victims. How would you like to be put on trial for a crime? And the judge introduced the case to the jury by introducing you as the defendant and the person who is accusing you as the victim. And then throughout the trial, have all the references to the complaining witness as being the victim. Is it so difficult to just use the term complaining witness instead of prejudging what the jury is here to determine as to whether there's a victim and whether there was a crime committed? So I don't know what I'll leave that comment at that. And then finally, I'm now reading about how bizarre and unusual it was to have the defendant pick the numbers out of the tumbler yesterday. And I would admit that I don't know that there's a large number of courts that do that, maybe not any. I do it because of an incident that I had in a case I tried in Racine. Oh, I'm going to say I estimated 20 years ago it could have been less than that. It could have been more. But it was a big case. I think it was a murder case, but I'm not sure. And there was a black defendant, and there were 13 jurors, one of whom was black. And when the clerk, the government official, drew the name out of the tumbler, it was a black, the only black. There was nothing wrong with it. It was all okay. But what do they talk about? Optics nowadays? Is that the word for things? That was a bad optic, I thought. I think people feel better when they have control. So ever since that case, I have, ever since that case, I've had an almost universal policy of having the defendant do the picks. It had nothing to do with anybody's race or anything like that. And I never had a complaint about it before. In fact, I haven't had a complaint about it here. But some people seem to be dissatisfied with that, and people who want to undermine the result of the trial. So some of the things that have been said too, I guess I'll comment on that too. These are five very reputable, competent attorneys that I've practiced with for years. And I think it's shameful, some of the things that are being done to these people. And when I talked about problems with the media when this trial started, We're there in part, not fully, but in part because of grossly irresponsible handling of what comes out of this trial. I will tell you this. I'm going to think long and hard about live television of the trial again next time. I don't know. I've always been a firm believer in it because I think the people should be able to see what's going on. But when I see what's being done, it's really quite frightening. Frightening, that's the right word for it. But back to the subject at hand.
So as you guys heard, like basically the judge was basically clapping back at the media. So he explained why he allows the defendants to select his jurors, and it was basically because the only black 20 years ago, the only black, the one and only black from 20 years ago, basically ruined it. Not ruined it, but for lack of better terms, they were the ones that was incorrectly picked, and he felt like it wasn't fair. So to stop that from ever happening again, the defendant and not the clerk will always be the one that draws the names of the juror. Now, a lot of people was just like, this judge is fucking cuckoo. He's 75 years old and he needs to get the fuck on. And I'm sorry for my language, but that's a lot. Like when I was on Twitter reading people's reactions, they was like, the judge got to go. And I definitely agree. The judge, because he's done this for so long, and I'm going to put it like this, it came off as if he was just very frank and matter of fact. And you can see this in anyone who's been in a profession for a long time, like doctors, dentists. The older they get, the less like personable they are. But for him, it wasn't that he wasn't personable. It was the fact that he was really, really, really coming off as if he already had a bias and he was protecting the thug. That is just really how it came off. And it wasn't as if he was really just trying to make sure this was a clean cut case. That is just the main people's opinions. And I can't say that I fault people for seeing that way. I personally agree. Like it was like, oh my God, like damn, let the prosecution do what they need to do, but it wasn't. And then after the prosecution and the defendants did go ahead and do their closing arguments, the judge was hell-bent on making sure that the juror knew the instructions. Like he kept saying, a lot of jurors don't understand this. This is really hard. Self-defense is hard. It's very hard to understand. So the deliberation went on for 4 days, but the judge talked for over an hour and explaining and breaking down everything. And it's like, dude, the jurors have the information. What they do with it is what they need to do with it. But he just would not stop pressing the issue of making sure that they understood because it was confusing. And like I said, I'm not sure if this is a common practice in the courts, but for a lot of people, and myself included, because this was something that I've never seen it. Like I've watched trials before, but I've never seen a judge behave this way. And it didn't come off as if he was a rule stickler. It really came off as if he really wanted the jurors to do what the hell he wanted them to do, in my opinion. But he was just like, I have to explain it. Do you guys understand? And after the verdict was ruled today that he was not guilty, when I say the judge was like, yes, I'm so proud of the jurors. They did a fantastic job. Everyone did a fantastic job. It was like, not once did the judge or anyone say, it's really sad that people lost their lives. Like, we know that you don't want to say victim. We know that you don't want to use these loaded terms, but this is a still very serious matter. And a lot of people do not understand just how serious it is when it pertains to standing your ground. A lot of people felt like this was something that was a political trial and that people had preconceived notions because of politics and optics. Like those was the common trends that was in the mainstream media: politics, optics. They just want to ban gun control. And we know that a lot of liberals are so serious about their gun controls. Their guns are their babies. They don't play when it comes to their rights to bear arms. So a lot of people was up in arms about that. A lot of people felt like people was ripping this thug's future away from him. And look, he's in college to be a nurse. Meanwhile, we have the other side of the spectrum, which leads me to my title. This trial was so disgusting to me, and the way that it was heavenly fetishized, as far as this was someone that didn't deserve this. He was fighting for his life. He killed a pedophile, because Rosenbaum was a pedophile and Huber was allegedly a woman beater. So they felt like he did the right thing to basically right wrongs. He was some type of vigilante / hero, and he has a bright future in front of himself. And it's just so sad that this came off of the breaks of Jacob Blake being gunned down and partially paralyzed by a police officer. And these people was outside protesting for Black lives and protesting for equal rights and police reform. And we have this type of case where the police was there that night. And another piece of evidence that was thrown out was the police said thank you for everything that the thug, Cal, and the vigilantes did. That was thrown out too, but they definitely said thank you so much for this. The police officer said this, like it's coming off real White Lives Matter, and that's just it was just mind blowing. So my closing arguments have way more to do with how I feel as a person. When I sit and I reflect on this case and I think about my people, it breaks my heart. And I think about Tamir Rice. I think about an 11-year-old boy that was killed by a police officer for looking like he had a gun and he did not. I think about Karif Brown that was incarcerated in Rikers Island, one of the worst facilities to ever be, for 3.5 years over stealing a backpack. I think about Central Park 5, who were little boys who were younger than Cal, the thug. And they were put on the stands and they were called some of the worst names possible. Thugs, gangbangers, menaces to society. I can't help but to think about Trayvon Martin, who was killed by Cal Rittenhouse's idol, George Zimmerman. And I don't know that this is his idol, but I really, 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 really feel like he will be the next George Zimmerman. A lot of people don't realize that George Zimmerman fought the same charge. He was standing his ground. And this man has been a complete menace to society since then. And he has hurt not only the family of Trayvon Martin, but he continuously shits on them day after day, following him being found not guilty of all of his charges. Cal Rittenhouse was a 17-year-old thug, and he had no business being there. This is why y'all fight up for the lives and the rights for these blue wearers, these blue workers. If this was their job, they needed to make sure this happened. In no way, shape, or form should this 17-year-old thug, gangbanger, Grand Theft Auto, I want to live in real life, should have been out there impersonating an EMT, walking around and killing and having no regard for human life with a military style gun. So yes, a lot of people is disgusting, and a lot of people don't have tolerance for this because it's a shit and it's a slap in their face. And just to throw it out there, Jacob Blake's officer that partially paralyzed him will not be held guilty of anything either. So while we fight an uphill battle, and these same commentators that was able to see glimpse of hope in this thug Cal, they zoom into what we do or don't do, and they justify us being wrongfully mistreated in the hands of the police, in the hands of the court system, in the hands of the media. They justify it. But this right here, this, if you guys did not know, to look up your rights, to get informed, to make sure you guys are looking up the people that hold power in your state, this is why. This is why. You guys want change. You guys want to know what's going on. You guys want to be in the know. Look up the lawmakers. Look up the people that actually make the deals in your state, and make sure that you are actually voting. Okay? Now, that's how I'm going to wrap up this live. I thank you guys so much for rocking with me. I know it's a late live. I know it was a lot of information. If you guys have any other comments, feel free to comment below. If you have any other cases that you want me to talk about, I will. I am going to be covering a Black man in my hometown that just got justice as of today. It was a very, very big deal. I am going to be talking about him on Monday, and I am so excited to talk about this. This man was killed wrongfully by the KCPD, and then they went on to plant evidence on him, but that officer was convicted today of murder. So I am so excited to actually bring home something that's good to talk about on this channel. But again, get informed, stay in the know, and I will be rocking with y'all till the wheels fall off, and we will continue to break down this fucking injustice, okay? Peace out, y'all. Good night.